doing what's necessary to effectively have a practice that is compliant with today's law for a DC. So Dr. Cross is an expert in compliance. He's a certified professional compliance officer, and he's also been active in the profession as everything from president of the Florida Chiropractic Association to currently president of COXA, which is the organization that pulls together all of the chiropractic state associations under COXA. Dr. Cross, good morning, and talk to us. How does my signature save me money? How's it make me money? I like that better.
Thank you. Thank you for the introduction. Um, the signatures today seem to be more and more important than ever before. So we're going to go through this, and hopefully by the time we're finished today, you're going to have some nice practical information that you can use in your practices this afternoon. So first, I want to thank our sponsors, Dr. Weiniger with Posture Practice, and then also Chiro One Source. Thank you for promoting our webinars, and they're both entities that I definitely recommend for everybody to use. We changed our name a while back. We used to be Obamacare Compliance Manual, and now we're chiropracticcompliance.com. Just want to make sure everybody's aware that we're the same thing. Remember, this is presentation is strictly for educational information purposes. I'm not an attorney. This is not legal advice. We are going to be talking about some things that does get into that realm, but this is more for practical and day-to-day stuff. I am not an attorney, so please do not construe this as being legal advice. We're going to work primarily or focus primarily on the typical office, 1 or 2 doctors, less than 15 employees. This is the typical chiropractic practice in America. Yeah, we've got some big practices, but the average practice, this fits. And so many of the government regulations uses the 15 employee cutoff, and so we're focusing on the typical practice. And so that's what we're focusing on today's presentation and with our complete compliance program. So today, your signature, something so simple but so powerful. I mean, it really is. And one of the things that I've been surprised with, and I've seen this more and more with the students that I teach, as most of you probably know, I'm an instructor at Florida Palmer, and I basically teach the business courses as the students get ready to graduate. But one of the things that has surprised me is when we've talked about contracts, and I talk a lot about contracts in those upper quarters because they're getting ready to either go out and work as an associate or they're going to go out and open up on their own. But contracts are very, very important to those students and new doctors. Well, signatures for us old-timers, like Dr. Weiniger and I, mean a lot more, it seems like, than to the younger doctors. Signatures, in the past, it was like you had to sign everything. Now, with doing so much activity online, you don't really have to sign on the dotted line anymore. You either check a little box or, some way that you're showing that, this is what you've agreed to do, but it doesn't take a signature. And so what I'm seeing with the younger students and the younger doctors is they don't really have a good impression or a good awareness of just how important that signature is in a legal standpoint. And I want to touch upon that just briefly before we go into some of the details and some of the day-to-day stuff, is just to remind everybody how important that signature is. Because there are things out there and there are entities out there that will use your signature against you. And so if you have a better understanding of what your signature does and what it is, I think will help as you're looking at provider agreements, as you're looking at different types of agreements with the different government agencies, and you're looking at your documentation in your office and the different requirements that you have to have and with the documentation to prove that something happened. Your signature is that evidence, as it says there, evidence of the identity of you. That signature represents you and that you have provided that signature to show that you have deliberately signed that and base that upon your informed consent of what you're signing. It shows your intent, that this is something that you've read, that you've understand, and that you agree. I get calls from recent graduates, young doctors, that are running into problems with contracts that they've signed as an associate or non-compete clauses and things like this. And frequently they tell me, well, I ask them, did you sign the contract? And they say, sure. I said, did you understand it? No. Well, if you didn't understand it, why did you sign it? And I get those kind of blank answers. They just don't really think through what they're signing. And then once they've signed it and then something happens, they realize they should have read that. They should have actually understood everything in it before they signed it. And that is so important. There are different things that happen. Records requests sometimes coming in from Medicare. You'll find a form in there and it asks you about your fee schedules, if you have more than one fee schedule, things like that. And if you sign and answer it incorrectly or answer it in error, but you've signed it, you've just signed a legal document stating that you're committing fraud or that you're actually breaking federal regulations simply because you didn't read through or didn't understand what you were signing. And these are coming back to burn doctors big time because they just signed it, didn't think about it, didn't read it. Oh, it's just something for Medicare or it's just something for Blue Cross, and don't really pay attention to what they're signing. And then later it comes back to haunt them. I've had doctors call me up, and some of the insurance companies require now that you do electronic deposits for your insurance claims. Well, be careful of those contracts, because sometimes if you aren't careful, those contracts allow them to pull money back out of your bank account. And if you don't read those contracts and really go through them with a fine-tooth comb, they have the ability to pull out however much money they feel that they've overpaid you, with you having no recourse because you've already authorized them to do that.
Dr. Cross, I need to pop in for a second to underline this, because if you're not paying attention to what Dr. Cross just said, this is a big problem. And I think you're right that the culture of people just clicking a box and thinking that it is okay because everyone does it. And if there's a problem, well, nobody reads it all. I just updated my iOS off of my iPhone to the next version of it, and I think it was like 64 pages of fine text. And nobody reads that stuff. But part of it is they're training us to not read this stuff. And what Dr. Cross said is absolutely true. But some things you can't negotiate. I can't negotiate with Apple, and my feeling is if there's something horrible about it, I'm going to hear about it in the world because someone's going to scream about it. And that's why I'm never the first to upgrade to the latest thing, because sometimes there are things that change. But in terms of contracts with an individual, doctors have to really get that when you click that box, this is what you're agreeing to. And it's not more flexible down the road because you only click the box. And if you're in front of a judge and the judge says, did you sign this? It's a really short trial, because any lawyer will tell you are responsible for that. You're agreeing to it and agreeing to the consequences. You may not like them. You can choose your actions. You live with your consequences. So them pulling money out of your bank account, which is a thing that's going on, is a dramatic thing, and your practice can be impacted if you think you've got 10, 20, 30, 50 grand in the bank, and one morning you come in and you find out that you bounced your rent check because last night somebody went in and pulled something back out for 3 years that they overpaid you, that you thought that you didn't have to argue back about the stupid form that they were sending you, and you said, what are they going to do about it? They just took the money. And if you go to court, you'll lose because you didn't argue about the form in the time that you had from a legal point of view. This is important stuff. Doc, please continue.
Right. And with when you do that online with the checking the boxes, you're checking a box that says something that's actually addressed specifically to you. And so that establishes that precedent or that relationship just by checking the box. So don't think that you have to write your signature to be tied into one of those agreements. Simply checking those boxes as stood up in court. So be careful about that, and really, really, really read through things that you're getting from your provider agreements, etc., because it can come back, and as you said, you may have a huge amount of money pulled out of your account, and you may have no recourse at all because it depends on what you sign in that contract. So be very, very careful about that. Electronic signatures, there's different ways we can do them now with Adobe and different things, and those, they do stand up in court. So it's not just something that you're sticking into an electronic document. This is something that does stand up in court and does establish that a legal relationship, that legal responsibility. So please always read whatever you're going to sign. Don't assume that your office manager read it correctly. Don't assume that somebody else on your staff has done that. Make sure because it's your signature. It's the doctor's signature, and that establishes that legal relationship. And it's hard to ever back up and say, well, I didn't know or I didn't understand. That just doesn't apply once you put your signature to it, because your signature implies that you have read it and that you're informed of what you're consenting to. So please be very careful of that. I've seen too many doctors get burned. So we're going to talk about some nuts and bolts about your practices, some stuff that you need to be checking, and some things that I've seen from audits and talked to other people in the profession that are watching what's happening with the audits. And these are things that you should be able to utilize and make sure you're double checking yourself as we go along. So these are some really nuts and bolts type things that should be pretty practical for you. Pardon me. Audits are still on the increase. Remember, the audits make them money. Medicare knows for every dollar that they spend on an audit, they recoup $7. Think about that. Every dollar they spend on an audit, they recoup $7. That's a great investment. So why would they stop doing audits? Why are the insurance companies going to stop doing audits? They're not going to, because it makes them or saves them money, and so we see them continue. And the thing is, at this point, they're actually starting to focus more and more on the small offices, on the single doctor offices. They're doing data mining, so they're still picking on the guys that have the most trouble, but they've already went after the bigger offices, so now they're focusing more and more on the single doctor and smaller offices. So don't think you're going to slip by, that you're going to be under the radar. They're going to get to us all at some point. Remember, the Office of the Inspector General said, they were going to check everybody in the country. That was their goal. And so don't expect to get out of it. They're going to come after you to at least check you over at once, if not more. In the last 3 years I was in practice, I got hit 3 times for the big audits. No problem, but they're doing it. They're checking. And the devil's in the details. Little things that you think, well, it's not a big deal. Well, when you do that over and over and over, it becomes a big deal, and it adds up. So it's still such a thing that we have to, today in our market and economy the way it is, we have to practice as lean and mean as possible. We need to be as efficient. We need to save time. Time is money. So anytime that you can do something that saves a redundancy, that saves having to go back and change things later, that saves you money, saves you time, and in the long run helps the practice. So this is something you need to really pay attention to and stay on top of. One of the biggest things they're still using against us with insurance denials is that this treatment note was not signed by the treating doctor. It has to be signed by the treating doctor. Of course, you can go back later and do an attestation and make a statement for each claim that you send in without the signature on the notes, but it's time consuming, costs money, takes a long time. Do it right. Do it right the first time, and you don't have any problems. You don't have to worry about them coming back and denying it simply because you didn't sign the soap note. Where did I get that from? Oh, I see. I see what happened. Excuse me. Technical difficulties here. I hit the wrong button. Okay. So, one of the things that I've had doctors argue with me about, they did sign it. Okay, that's great. Can somebody read your signature? If you look at those 2 signatures on the screen there, John Hancock, easy to read. What's the other one say? I couldn't tell you. Maybe RC, but it could be a PC, it could be, I don't know. If you cannot clearly understand what the signature represents, it doesn't count. And they denied claims just for the fact they could not read the signature. So if you've got one of those squiggly line signatures, and so many doctors do, that's not going to do you any good unless you print your name below the signature. Okay,
Dr.
So
Cross,
what do you do?
I got it. Okay, what you do is the question, because I got a couple of questions. I got a couple people asking questions on that point. So keep on going.
So When the signature you use on your soap notes is not the signature that you're going to use on your checks. Okay, it's not. It's just like autographs versus signatures. All right, they're different. You can autograph something and it look completely different than the signature you're going to use on your checks. So when you're signing your treatment notes, use a signature that you can actually read. Okay, so you can read that it says John Hancock rather than a bunch of squirrely squigglies. That way you don't have to worry about printing your name below it every time. It's just simple like that. It does not have to be the same signature that you sign on your checks. And the easiest way to do it is just sign it in such a manner that's easy to read, and you solve the problem. Same thing with the EHRs and their signatures that the EHRs use. When you actually, first write that and put that into your system, again, it does not have to be the signature that goes on your checks. It shouldn't be, really. It should be a signature that you can read who actually signed it. So do that on the little pad when you sign in for your software, that your HRs that actually put your signatures on the soap notes for you. Print it or sign it so that it can be read, and then you don't have to worry about printing it every time. So just simple little things like that will save you lots of headaches, save you denials from insurance companies, and makes a big difference in time, when you're looking at a lot of soap notes and a lot of denials just because of the way you sign your signature. Dr. Weininger, you had a question?
We're good. We're good, Doctor. We're good.
Okay.
Dr. Chris, okay. We're good.
Okay. Oh, this one, I get so many comments too and questions about signatures. Is it just for Medicare and Medicaid? No. Almost all of your insurance companies have these same requirements. I know Aetna has been using this big time with doctors. And I know it's in Blue Cross Blue Shield's requirements as well. They're simply denying, and then it takes time to challenge and do a hearing. I mean, it just is simply putting your signature that's readable on your soap notes saves you so much headache and time for your staff.
Okay.
And remember, many of your state practice acts require them. Go ahead.
We are having some questions with this. So if you have an illegible signature, like some people do, myself included, can you use a stamp for signature?
Sure.
Okay. Any
caveats?
caveats?
The risk is that somebody can place your signature on something that you didn't read. But if you're careful and you know the person's using that stamp is only going to use it where you've authorized it, then there's no problem. But there is that risk that can be used. Here's another reason why you don't want to use the same signature on your treatment notes as you use on your checks. If the signatures are totally different, then nobody can counterfeit a check or write a check and use your stamp against you that way. Use two different signatures, one for your treatment notes and one for your checks. Don't use the same signature for both.
And I've got a question about EHR, but one personal thing is I've practiced and I've used a stamp because we had a stack of insurance forms and I didn't trust anybody to be using it, even though I did a lot at a time. Having a stamp that was in my drawer locked, I took it out, I stamped it, I put it back in. It let me do it more quickly with a lot less tedium than signing my name 88 times. Also, EHR, do I have to print it out, make a signature on it? I mean, how does it work with EHR? Can you talk about that for a second?
Sure. Well, most EHRs, you actually have to go to your sign-in pad so you can actually enter your signature into the system. Once you've saved your signature then into your EHR, the EHR then will use that signature over and over again at the bottom of your treatment notes. Most of the EHRs are set up so that they won't close the treatment note until you actually authorize them, and it authorizes them to put the signature at the bottom. So again, this is where you want to use a signature that can be read rather than the signature that you use on your checks. But then your EHR takes care of it. Doing it one time, then you just click the button when you're finished with the treatment note, and the EHR puts it on there. And that's fine. That is all that's required for the insurance companies and for your state practice acts that require them. So, it makes it very simple, very easy, time savings as well. But the way you were talking about using the stamps and keeping it yourself, that's the best way to do it. But I've walked into a lot of offices and found that laying there on the front desk was the doctor's signature stamp. That's dangerous. But there again, that's one of the reasons why I recommend that your signature for your checks is different than the signature you use on your treatment notes. So if somebody just happened to walk off with your signature stamp from the front desk, that's not going to do them any good at the bank. It'll be just for your treatment notes. But yeah, the way you were doing it and keeping it locked up, that's awesome. That's the best way. But I know a lot of practices where that's not was what's happening. So be careful about that, and be careful that, like I said, the best way is just use two different signatures. And we've seen here in the last, probably 9-12 months, we've seen so many more doctors are being reported to their chiropractic boards by the insurance companies. Pardon me. Mainly because the insurance companies are getting tired of doctors not cooperating, not responding to their requests for treatment notes. And then when they do get notes, then the notes are so bad they don't meet the minimum requirements for the State Practice Act, so they turn the doctor in. And remember, this applies to cash practices too. Cash practices, this applies to you too, because your State Practice Act still requires you to do treatment notes in such a manner that you support medical necessity. And that's what the insurance companies are looking at. So if you send them a soap note that doesn't meet your State Practice Act requirements, obviously it's not going to meet medical necessity either. They're going to deny the claim because your notes aren't any good. And when they get pissed off at you doing it bad so many times, they're going to turn you into the state boards. We're seeing this more and more across the country. It's one of the ways that the insurance companies are basically forcing doctors to do a better job with their notes, and hopefully forcing more and more to get EHRs. We still are way behind on the medical doctors on EHRs. I think it's over 95% now of medical doctors have gone to EHR, and still only about half of the chiropractors are. We've got to start using the EHR, guys. It's time. It's here. Let's do it. And it makes so much difference with the processes within your office. But insurance companies are turning doctors in more and more because of the poor notes and not having the notes signed. So make sure that you realize whether you're cash or whether you're a mix of insurance and cash, you still have to do good notes based upon your State Practice Act. It's not the requirements of the insurance companies. It's not the requirements of Medicare. It's your State Practice Act. And, I've read probably 45 of the 50 state practice acts. I've even read Puerto Rico's. I mean, I've looked at these. I know what they're saying, and you have to do good notes. That's just something that's across the board, across the whole country. So don't let them use that against you. Don't think that, I'm a cash practice, I don't have to worry about notes. Yes, you do. Your State Practice Act tells you have to worry about your notes. So from here forward, I'm going to sort of be assuming that you already have a compliance program in place, because we're going to be focusing on things that we see showing up in the audits. And these are things that show up in audits with people that have compliance programs already in place. It doesn't matter whether it's the program that I've developed or others that are out there. We're going to assume that you are in compliance with those programs. And then we're going to talk about the problems that we see that come up in these audits over the year, and so that you can make sure that your compliance program is on top of this. Make sure that you don't get blindsided by an audit when they come in and start looking for these things. Because remember, insurance companies in their provider agreements almost always say, and you signed it as a provider, that your practice is compliant with all of the government regulations. So when they come in to do, let's say Blue Cross Blue Shield comes in to do an audit, they not only want to see your treatment notes, but they're going to ask to see your policies and procedures. They're going to want to see your compliance manual. They want to see your compliance program. And now we're seeing more and more letters coming out from the insurance companies wanting to see your annual risk assessment. That risk assessment gives them a snapshot of how things are being done in your office. They can look at that risk assessment and see, are you compliant, like you've signed on your provider agreement that you're compliant or not? And, we've seen some guys get kicked off or get kicked out of the provider agreements because they're not compliant, but yet they said they were. So don't sign something saying that you're compliant and then not have a compliance program in place, assuming there's nobody ever going to enforce that, because now we're seeing the insurance companies themselves doing it. And there's a major reason for that. Remember, all these insurance companies, almost all of them have some sort of Medicare secondary program. So they're making contracts with the federal government, with CMS, that they're going to be practicing, in a compliant manner with all the regulations. And in their contracts, and they're also contracting with the feds that all of their providers are also compliant. And so they've got to enforce that with their providers to make sure that they don't violate their contract with CMS. So they've got a major investment in making sure that you're compliant so that they're in compliance with their contracts with the feds. So we're seeing this more and more happen, that Blue Cross is not just coming in and looking at the claims or the patient's files. They're wanting to see your programs on compliance. They want to see that you're doing your annual risk assessments. They're wanting to see this. So, I'm going to assume that you've got something in place. And we're going to talk about the things we see. And if you don't have something in place, well, I've got it covered. We'll talk about it later. It's only $499. We're going to talk about it later. But this is something that I put together for the single doctor or the 2-doctor office to make it very, very cost effective. We'll talk about this later. So what are some of the compliance problems that we've seen during the audits? Well, one of the first things you're supposed to do when you have a compliance program is to appoint a compliance officer, okay? And when you read the actual regulations, they want a letter or signed by the doctor and in the actual employee's personnel file, demonstrating and documenting that that person is now the compliance officer for the clinic or for the office. That's a legal document. That's a legal requirement. So they want to see that that's signed by the doctor. It's not just an email, or it's not just a simple memo that's initialed. They want to see a letter from the doctor or from the owner of the practice to the person that's actually your compliance officer, very clearly stating that, because that sets a legal precedent. And that precedent then can be used against the compliance officer if, when they're doing let's say a breach investigation, something like that, that can be used against a compliance officer, because they have a legal document appointing them and making them responsible for these actions within your office. So this is something that we've seen, when they've gone in and there's been staff turnover, and when they ask who the compliance officer is and they point to who it is, they want to see the personnel file, they want to see the letter that points to compliance officer, and they don't have one. They have one for the previous person, but that doesn't work, because you need somebody who is your current compliance officer that has a legal document stating that. So make sure you're keeping that current. If there's turnover in your office, make sure the new person that's compliant officer has that in their personnel file. Another one, and remember, today you have to have more than a HIPAA manual. A HIPAA manual, back 7 years ago. Actually 4 years ago it became more strict, but over the last 4 or 5 years, it's gotten to the point where you have to have an office policy and procedure manual. Because how can you demonstrate how you do things in your office to be able to go through the breach investigations and things like that if you don't have a written policy and procedure? And remember, they've already said the old handbooks that we all used is not appropriate and doesn't stand up in court. So you have to have a policy and procedure manual that's written in the proper method. I've given webinars on this in the past on how you write those so they'll stand up in court. And that's what you need. Well, not only do you need the policy and procedure manual, but you've got to have a statement typed up, written in there, that the doctor adopts the policies and adopts the procedures and authorizes the clinic to use those, and it has to be signed. Okay, it can't be just a paragraph at the top of the policies and procedures on your first page. It has to be signed. That signature then makes that a legal document, and you can use that to protect yourself in court in a malpractice situation or a breach situation, things like that. So, but you have to have it signed. Okay, it can't just say that the doctor approved it or adopted it. It has to be signed off. Staff attestations. Whenever you change your office policies and procedures, you have to send them out a memo in writing, and you must have those signed that the staff have seen it, that they know there's been changes, that they understand it. Again, you've got to have those signed. So however you maintain the records of that, whether you just keep a file and put all the attestations in one file, or whether you put them in each individual personnel file, that's up to you. But you have to have an attestation that shows that all of your staff knows that these changes have gone into place. You're using new policies and procedures, and their signatures then saves you a lot of money. And we're going to talk about that in just a second. But those staff signatures are very, very important. And this is one of the things we need to make sure that those are getting signed whenever you change those policies and procedures. So make sure that's in the personnel file. Hopefully, everybody has a personnel file for all of their staff. I have walked into offices in the last couple of years, and they still do not have personnel files for everybody in the office. That in today's environment with Department of Labor regulations and state regulations, you've got to have a personnel file for every person in your office, people. You've got to. You've got to step up. You've got to act and be professional in how you're doing this, including keeping personnel files on all your staff. Yes, it's a little bit extra paperwork. Yes, but you got to do it. You can't get away with not doing it today. Even if you just have one employee, with one employee, you still have to follow a lot of these regulations from the Department of Labor, okay? So, you can't get around it anymore. Just do it. Keep the records that you need, and you'll stay out of trouble. One of the things I want to remind everybody is that when you hire a person, a new employee, they come on board, the first day, their main requirement is to read your policies and procedures, okay? When these programs first came out from the federal government, NIST, the National Institute of Standards and Technology, actually was given the responsibility of how to interpret a lot of these regulations. And they state over and over and over in their training, you need to train your staff on the first day on security, cyber security specifically, but all of your HIPAA information and the security of your cyber records, your database, et cetera, the staff needs to know this the first day on the job, okay? So don't put it off. If you're one of the offices that just does HIPAA training and security training once or twice a year, you can't do that. What's going to happen if you hire somebody, your next training is not for 3 months? Well, during that 3 months, that person's not read your policies and procedures. They may be doing all kinds of things that are going to get you in trouble. So you need to make sure you're training your staff the first day on the job so they know what they can and can't do on social media, what they can and can't post on Facebook. These things are getting doctors in trouble. My office, small town, my CAs knew a lot of the patients from the community. And so it was a constant battle to remind them that they couldn't take pictures of the patients and post it on Facebook. They couldn't take pictures of the grandkids that the patients were bringing in and putting them on Facebook. These are things that you have to realize that, today's our CAs especially, they're always on social media, they're always on Facebook, they're always posting pictures. Well, when they come into your office, it's a total different environment. You've got to make sure they understand from the first day of employment, they can't do that anymore. You can't do that unless you've got those written authorizations from either the parents or the patient. So they have to know that from day one. It opens up so many problems if you don't have them trained on that the first day. FYI, don't forget, someone should be reviewing your policies and procedure manuals yearly. They're going to come in when they're doing these reviews of your policies and procedures, and then they're going to go to the different staff and have them, demonstrate that that's how they actually verify insurance, or that's actually how they get the information that goes on the claim forms. They're going to verify some of these to make sure that your policies that you have written are actually what you're using. What good is it to have a policy that's written in a manner to actually stand up in court and defend you when your staff aren't using that? That they're using something or totally different, or they're completely ignoring that policy and procedure. You must review those on an annual basis, making sure that the staff haven't decided to change things. And I found that in my office a couple times. The staff talked amongst themselves. They had a different way to do it, made more sense, more time efficient. That's fine. But you got to change your policies and procedures to make sure they reflect those changes. So any of those changes, again, you got to make sure you notify them in writing, and then they must sign those attestations that they're aware of that. If that's in place, that then establishes these things that you can actually use to protect yourself either in a malpractice situation or in a breach situation. So it's very, very vital that you do this and keep up with your policies and procedures on a regular basis. With a compliance program, you have to have self-audits. You have to be doing the certain ones a certain number of times a year based upon the regulations now. And, you want those to be signed off. Whoever's doing them, you need their signature on there because they're taking responsibility for what they've done. And I recommend that if it's not the compliance officer that's doing the audit, then the compliance officer signs off on it as well. That creates that double check system to make sure that there aren't things slipping through the cracks. If you're getting corrective action plans, once you've seen a problem with your self-audits, make sure that they're completed. Doesn't do you any good to write one up and then stick it in the file and forget about it. Do it, sign off on it when it's completed. And the same thing goes. Have the person that's doing the changes sign off, and then also the compliance officer. Those signatures are your proof that something occurred, and you can use that then when you want to combat whether an insurance company is trying to recoup services for 3 years, but yet you changed your processes 9 months ago. Well, from that 9 months forward, they don't have any reason to be able to recoup or to retract the money. So you can change and decrease some of these fines and this recoupment if you've got things in writing to show that you had a problem, you recognized it with your self-audit, you did a corrective action, and from that day forward, things were done properly, and then you save yourself tons of money because you have a written record, a paper trail to show that. And if you don't have that, it's just your word against theirs, and they're going to win. And this one makes a sense of that too. It's like this training logs, very important. This just like I've told the story many times. There was a dermatology group up in the Northeast. A laptop was stolen out of a car. They had reported as a breach because there was protected health information on that laptop. The laptop was never used. The information was never used that they know of. But when they went in and did the breach investigation, there was no record that the staff had been trained on breaches, how to prevent breaches, what to do when a breach happened. And so they were never fined for the breach, but they were fined $250,000 because they could not verify that the staff had been trained. They did not have a training log to show that. They did not have attestation signed by the staff showing that they'd been trained. So if there's no attestations, it didn't happen. So it cost them $250,000. Even though the staff said the training occurred, there was no record of it, nothing in writing, and it cost them $250,000. So again, your staff signatures on these training logs, that's what you have to have to be able to create that and be able to show your paper trail. Let's see, what's the next? Business associate agreements. That's one of the main focuses this year of the OIG audits, is checking on the business associate agreements. So hopefully at the beginning of the year, like you're supposed to with the compliance program, you reviewed your business associate agreements, and any of them that were, getting old, shall we say, had to be redone. And because of the changes in the regulations, you needed to have the new wordage, etc. These business associate agreements then need to come back to you to make sure that they were signed, and make sure that the signature that you have on file, and the ones that you didn't redo, is the current management. But the person that signed it is still the president, or is still the CEO, or is still the manager. Because if there's been a change in personnel, you need a new business agreement. That business associate agreement was signed by somebody that's no longer an employee, so it's no good. You've got to make sure it's signed by a current management person, somebody that has the authorization to sign those. So you need to review those on a regular basis. That should be part of your compliance program. And then you need to make sure that, if you sent one out to be re-signed with a new person, that you got it back. Just because you sent it out, don't assume that it's going to be sent back to you. You need to follow up, have a system set up so that your staff can follow up and make sure that they got it back. Now remember, there's other things that our signatures are vital on besides just HIPAA, HITECH, and Obamacare, and all of the PPAC and all of those regulations. There are other regulations from Washington that we have to follow in our offices. And so often we get kind of put blinders on. All we think about is our cybersecurity, all we think about is HIPAA, all we think about is high tech and that kind of stuff. But there's so many other regulations and laws that we have to follow as small businesses. And remember, we're small businesses. We're actually a micro business, but we still have regulations that we have to follow. And they want, from the Department of Labor, the regulations there, they want to make sure that all of your personal information is current. Now, I've seen this come up in a couple audits where they came in and did an audit due to a breach. Well, one of the things they do when they're looking into a breach is you look at your notification process. Do you have a process to notify your staff that there's been a problem? Well, where do you find out their contact information? How current is that? I know a couple of cases where something happened and, the personnel file had, an address that the person hadn't lived in for 5 years, or the phone numbers were all incorrect. They want to make sure that you can contact your staff ASAP. They want to make sure that all that information is current and correct. So when was the last time you went through your personnel files and had everybody update their addresses and phone numbers? This is something that needs to be current. You need to be doing this on a sort of regular basis to make sure that you have the correct information if you have to get up and catch somebody when there's a problem. This is something they look into. Are your W-4s current and correct? When was the last time you had your staff go through and do W-4s? If it's been 2 or 3 years, well, you may have had divorces, you may have had children. There's all kinds of things that will change those W-4s, and if you don't have a correct one, well, guess what? Now you're violating Department of Labor regulations. I-9s, this is something we had to start doing a few years back with immigration and ICE and all of that. Do you have a current I-9 on file for all of your staff? The I-9s especially have some pretty hefty fines. So again, these are not things that you can ignore just because you're a small office. They're going to look at you and want these things because you have employees. And, a lot of the stuff is required with just one employee. So make sure you're keeping current with all of these as well, staying on top of them. It can cost you big time. And as I've said before, we know, we've seen this over and over when, let's see, the Medicare goes in to do an audit and they start seeing problems for Department of Labor, et cetera. They're required to report that to the Department of Labor. So you may start off with just a simple Medicare audit, and we've seen as many as 5 different government agencies in an office that it just snowballed because they kept finding more and more and more and more problems. So you can't just follow the HIPAA regulations today and expect to slide through on anything else. They're looking for these. Remember, it's all about money. They want to recoup and they want to fine you for anything they possibly can, and they try to do it. So, don't expect to slide under the radar anymore. We can't do that. You expect to be gigged for everything they can find. So the more paperwork, the more documentation you have, the safer you are. OSHA. OSHA is really, really simple in our offices. Pardon me. We don't have to report anything, but we have certain things that we have to do every year as a small business, such as your annual safety review and making sure that you're logging that you're doing it and that the safety review has been signed off on by the safety officer in your office. These are just simple, really easy things to do. I mean, OSHA even gives you the documentation and the forms that you need to fill out. All you got to do is go to the OSHA website and download them, put them in a binder, do it once a year, document it, sign off on it, and you're done. But you've got to do it because when they come in and do one of these, major audits like this, and they find that you're not doing these things, well, there is fines against you for not following through on the OSHA regulations. So, like I said earlier, you cannot expect to slide under the radar anymore. They're going after us. They're going after all providers, trying to recoup and find for as much money as they can against us. It's just, it's just money, and that's what they're after. So make sure you're following through, and even these little things add up over time. And when they come in and do these and they start seeing all these little bitty problems and they get more and more people involved, they dig deeper and deeper and deeper, and it can be an astronomical problem at the end. So please make sure you're following all the regulations, not just HIPAA and high tech. Okay? And once you have a complete compliance program in place, it's not so much trouble. It's just ABC, following through the regulations, following through the directions, doing this month, doing something else next month. Once you have a compliance program in place, it really isn't that difficult because it should have things set up so that it reminds you every month what you have to do. Some of you created your own. Well, hopefully some of these things we've talked about today has helped you see where you might have some weaknesses in your program. But if you don't, we've got you covered. I created the OCCM manual program specifically for doctors' offices of our size. And, it's got everything built into it. It's a complete self-audit program. It's got all your logs, all your training program, all the attestations, all of that's built into it. And all the required policies and procedure manuals, background checks, tiered disciplinary procedures, all this stuff is built into it. Now, I set this up for the typical, like I said, 1 to 2 doctor office, 15 employees or more. This whole program, whether it's the forms and tools, whether, because those have all been, the ones that need to be reviewed by an attorney have already been reviewed by an attorney, so you have to worry about that. The programs for putting it into play, the training programs, the reading assignments, all of that's put into a program to make it easy for the staff and easy for the doctor. Safety manual, all set up there for you, very, very easy. All your human resources, your applications, your interview questions, appropriate questions to ask, all of these different things are built into this one program. All right, including your compliance stuff, including all your daily operations and your administration. All of this is done in a manner that's customized to your office. All right, each office is different, and that's what the government wanted. The OIG, expects each compliance program to be a little bit different because each of our offices is a little bit different. So it shouldn't be the same. So each of my programs is customized to your office, and it's set up to take about 6 months to put into place. Okay. I did this so that it wouldn't overwhelm the staff or the doctor. You do a little bit this month, you do a little bit next month, but by 6 months' time, you're going to have a completely compliant office. You're going to have all the things you need, the trainer materials. I'm not expecting you to bring trainers in from outside. This is set up so that either the office manager or the doctor or the associate can actually become the trainer. All of the materials they need to turn around and train the staff is provided. Okay. And like I said, it's designed to meet all of the Department of Regulations, Department of Labor, IRS, and all the other stuff. I mean, it's not just for HIPAA. It's not just for the high tech and those type of things. This is to cover every regulation that we have in our offices that we need to be compliant with. And it's all set up to be as compliant as possible and to make it as easy as possible for you to put into play. There's other companies out there, there's other groups out there that, have compliance manuals and, they break them up into different things. But I put all of this together so that it would be very easy for the single doctor office to put into play. And I wanted to keep it at a price that was affordable. If you look at some of these others, it may cost you $1,500, $2,000, as much as $5,000. But it doesn't necessarily need to be that detailed for our offices. Now, if you've got 6 associates, 3 locations, this is not going to work for you. You may need that $5,000 program. But if it's just 1 doctor or 2 doctors in an office with a few CAs, this is what you need and all you need. Now, we're regular doctors. We're going to take off next week, just like everybody else. We're going to close down on Wednesday. And we gave you a little coupon here that if you get things turned in by Monday, so we can get things sent out to you on Tuesday, we're going to save you a little bit of money because we're going off for the holidays on Wednesday and won't be back until next week. So if you use that little Save 60 coupon, you'll save $60 off of the price. Dr. Weiniger, I'm sure
Yes.
you've got some questions.
Yeah, I've got questions. If I haven't done this now, can I start now? To me, the answer to that is an obvious one. And Dr. Kort did not go over this, but they are looking not to nail people if they don't have to, not they don't want to, but if you can show best effort at a point in time, it's harder for them to nail you. If you haven't done anything, you're painting a target on your back. So the more you start to do something now, even if you haven't finished it, if you have a plan of today we're going to do this and next month we're going to do that, that's evidence of a plan. And so this is why my suggestion for people that we work with from a posture practice point of view, that they have some kind of program in place and they be doing it, which means like one meeting a month once you got things going to tap the bases and make sure everything's signed, make sure that people are trained in what you're doing. um, a question about the deal, which is the best deal that we've done in this year and will be. It's it needs to be purchased by Monday end of day. If you're thinking about doing it, pick up the phone now and give a call. The number's over there, or go to the website chiropracticcompliance.com. You can get it on a CD or you can get it on a download. I personally kind of like CDs better because they're easier to always have there. I have a lot of stuff on my computer, but if you like download, you can download it as well and have it right away. Your call. Um, other questions right now? That's more of a personal question. If you have any questions, please ask. There's a couple of personal questions that I'm going to forward on to Dr. Cross. That's not, especially if you're already getting questions from an insurance company. This is not an everybody question. Dr. Cross, do you have anything else right now? Last call for questions, Dr. Cross. You want to wrap it up?
Right. I just want to follow up what you were saying, and I've seen this many times already. If the auditors walk in and they ask you or your staff, for these things, and you're just like the deer in the headlights. What are you talking about? Or no, we haven't. They're much more apt to go after you. They're gonna sock it to you. But if they walk in and you say, well, we're putting a program into place right now, we expect to be finished in 2 more months. We've got this much done, this much done, this much done, but we're working on it. They are much, much more likely to ease off and not go after you for everything they possibly can. They want to see that you're trying to be compliant, and that's the idea. They want to, they know that every office needs to do self-policing, that we need to do our self-audits. And if you're showing that you have an atmosphere of trying to be compliant, they will be much easier, more lenient. And we've actually seen them lower fines from 480,000 down to 80,000. 80,000 is still a pretty hefty fine, but 480,000 is a heck of a lot more. And I know of a couple different cases like that where they could show, well, we started the compliance program 3 months ago, and here's where we're at. They have backed off on those fines. Significantly. But if you have nothing in place and you're not trying, you're just a wide open target, and they see you as dollar signs. They know, because most of those auditors, remember, get a percentage of what they recoup. So, if they're going to get 30% of everything they get from you, and they see you're a wide open practice with no compliance program, they're just going to be rubbing their hands together. Boy, oh boy, oh boy. They've got you. They're going to go after you. Whereas if you're trying, then you've got something to show them, and they will back off.
Well, Dr. Chris, I will disagree with you for a rare time on part of that, which is that they're being lenient with you because they don't want to get you. And this is Stephen Weiniger's personal observation and cynicism of dealing with government. I think they want to get as much money out of you as they possibly can. But if you've shown evidence that you are doing something, if push comes to shove and you go to court, then they know that they'll lose. So they'd rather have 80 grand in the hand rather than you having to spend, I don't know how much money fighting it, 30, 40 grand fighting it, rather than 480 grand, which case you have to fight it. And once it goes to court, it's more likely to be thrown out if you've been showing evidence, if you've been doing it, because the judges are going to be looking at it from that point of view. So even though the end result is the same, do it now, I think that the rationale of why they're being nicer is not the same. So from a strategic point of view, starting today, having a thing and being able to show every month that we're doing something in the direction is the key to protecting yourself from what can happen if you come in and you've had it's raining, but it's not going to hit me because I'm under this tree, and you're putting your head in the sand and your tail with a big target on it. So either way, if you haven't done anything, start doing something today. Dr. Cross, you want to wrap up?
I think that pretty well goes over it. Hopefully everybody got some practical information today. It makes you, look to see what you can fix in your practice if you've got some weaknesses in different areas, and have a nice holidays.
Have a great holiday, and again, we'll be around today. Call the office or go to chiropracticcompliance.com. And Dr. Cross, thank you very much. This is Dr. Stephen Weiniger signing off. Guys, have a great day and have a great Thanksgiving holiday. We all have so much to be thankful for, and that becomes cliche, and everyone says it, but feeling it, doing it, maybe looking at it as less about going shopping and more about spending time with people that you love and care for. Guys, have a great afternoon.